Happy New Year from E-Justice Project. 2023 brings with it a number of important new labor and employment laws that will affect California employees. Here are a few of them. As a result of Senate Bill 3, which has been responsible for incremental increases in California's minimum wage over the last several years, California's minimum wage continues to increase. As of January 1st, 2023, all employers, despite their size, will be required to pay workers a minimum wage of $15.50 per hour. This new minimum wage doesn't just impact hourly workers. California law requires salaried employees to make a salary of at least twice the minimum wage, assuming a 40-hour work week. As such, the minimum wage for salaried or exempt employees employed in the state of California is $64,480 per year. Hourly and salaried employees who are paid less than this amount may have a claim for a minimum wage violation and should contact an attorney immediately to understand their rights. In 2023, in an effort to combat pay disparities based on gender, race, and other factors, under Senate Bill 1162, California now requires employers to be transparent about employee wages. Under the new law, which became effective January 1st, 2023, employers with 15 or more employees must list pay ranges for both hourly and salary positions in all job postings. This includes all postings done internally, externally, or through third parties on behalf of the employer on social media and job searching sites like Indeed, Facebook, and even LinkedIn. Additionally, regardless of the number of employees, employers must provide pay information to any applicant or employee who requests it for a position they are applying for or holding. Finally, employers with more than 100 employees must submit annual pay data reports to the California Civil Rights Division. The pay data report will contain the median and mean hourly rates for each combination of race, ethnicity, hours worked, and gender within each job category. Under the California Family Rights Act, or CFRA, employers with 5 or more employees must provide a minimum of 12 weeks of unpaid, job-protected leave per 12-month period for employees to care for themselves or a relative with a serious medical condition. Under California's law, a relative has long included the employee's child, parent, parent-in-law, grandparent, grandchild, sibling, spouse, or registered partner. As of January 1st, 2023, the law has been expanded to allow the employee to select a designated person that can be added to this list. California's paid sick leave law that allows 24 hours or 3 days of paid sick leave per year has also been amended to allow employees to use sick leave to provide care to a designated person. A designated person is any individual related by blood or whose association with the employee is equivalent to a family relationship. This means that California employers must allow employees to take protected leave off to care for a relative with a serious medical condition, including a designated person, which can include a roommate, a very close family friend, a romantic partner, or even a next-door neighbor. An employer may not retaliate against an employee who requests or uses time off under the CFRA, but be careful. Employees can only designate one person per year as a designated person. 2023 brings the addition of a California bereavement leave policy. Previously, California employers were not required to provide bereavement leave. Effective January 1st, 2023, employers who employ 5 or more employees must now provide up to 5 days of job-protected bereavement leave to employees who have been employed for at least 30 days upon the death of a family member. The leave must be taken within 3 months of the date of death. However, there is no requirement in the new law that days of bereavement must be taken on consecutive days or all at once. Employees may therefore choose to take a few days of bereavement leave initially and a few days later on, as long as all time taken is within 3 months of the date on which the family member died. While this time is protected, meaning the employer cannot retaliate against the employee for taking up to 5 days of bereavement leave, the employer is not required to pay the employee during this time off. The time is unpaid. Employees may be required to use other accrued paid leave, such as sick time or vacation time, to cover the bereavement leave if the company has no paid bereavement leave or if the company's policy offers fewer than 5 days of paid bereavement leave. These are just a few of the new labor and employee laws for 2023. If you believe your rights have been violated or have questions, please contact eJustice Project. We may be able to help.